Hello, everyone. Welcome once again to the Kakis Dialogue. And the Kakis Dialogue is the Kamar Abdullah Kamar Intellectual Dialogue on Vote 24 TV. And we are here trying to make sure that we bring to you the issue in the press and trying to help you analyze this issue and harmonize them in a way that is going to show the path clear for our growth and development. Today's issue is a very critical issue and it borders on our laws and our governance process, and it also borders on the rule of law and human rights as well. And that is the reason why we took up this time to try to engage with this issue for the public understanding of what it is and what might probably obtain in the next few days to come. Yes, the issues that we are discussing today has to do with this notorious character called Prophet Key. Prophet Key is a very, very notorious character, and as a matter of fact, this character has managed to benefit from the Kamara Abdullah Kamara Act, the Kamara Abdullah Kamara law decriminalizing defamation. And so with that Kamara Abdullah Kamara law decriminalizing defamation alone, he managed to escape a suit that was wrongly filed by Julie Andy, the cultural ambassador of long time. Today, again, we see in the press that this guy, this notorious character, is facing a serious challenge from the Supreme Court. So, Prophet Key went up on his social media platform as he usually does and publicly accused the Chief Justice of corruption, alleging that the Chief Justice received money from individuals in the United States to construct a hotel in Nema County. And he has record on the Chief Justice. People have sent in complaint against the Chief Justice. And he also asserted that the hotel was a product of extortion and the Chief Justice should not be involved with business. The statement included vulgar and insulting language, which I'm not going to play here, including invective directed at the Chief Justice's mother. Because this platform is a civilized platform and it takes into consideration that there are possibilities that teens who wish to be educated about Liberia and what it ought to be will be listening to this platform. It is not necessary to play what Prophet Key stated. But everybody who knows Prophet Key knows that he doesn't conclude his statement without insulting anybody. He is notorious because he openly rain insult on his platform, and people who want to listen to those kinds of insult will obviously turn to his platform. I've always told my friends that I don't see anything that supposed to marvel people about Prophet Key insult, because he's not creative in his insult. He only used those olden time insult. He tried to make it look like he brought up his star. We might soon carry him to court for stealing some of our creations. But to be very frank, Prophet Key is way behind time in terms of insult. He has not caught up with modern day uh, innovation. But that is the case. He rained insult at the Chief Justice mother, and then also accused the Chief Justice of extortion and the of corruption, and that the Chief Justice is building hotels in Nima County, and the Chief Justice should not be involved in business, and the Chief Justice probably got the money that he's building the hotel from extortion or corruption. So this was an allegation by Prophet Key, and he said he's going to attack the Chief Justice openly. So the response from the Supreme Court was to issue a citation requiring Prophet Key to show cause why he should not be held in contempt of court. The alleged contempt arises exclusively from the speech made outside of the court. Prophet Key made a speech on his social media platform that was outside of the court, and I want the viewers to take note of that. We are going to get to that later. With no allegation of interference with specific judicial proceedings. So Prophet Key did not interfere with any specific judicial proceeding, and the statement that he made was made outside of court. Apparently, a lot of people misinterpreted the citation and were saying that Prophet Key has been held in contempt. And this was how the Chief Justice responded to that. I will play the Chief Justice for you so that you can be able to hear what the Chief Justice said about that. This is the Chief Justice.
Radio, social media, that the Supreme Court has heard one Justin is here, otherwise known as Prophet Key in contempt. I think this is an opportunity for me to clarify that the Supreme Court of Liberia has not quote unquote Prophet Key in contempt. The Constitution of Liberia gives freedom of speech, freedom of expression for all our citizens. And the Supreme Court of Liberia guards that freedom very, very well. The same Constitution also gives the Supreme Court of Liberia the right to interpret the Constitution and laws of Liberia. And whatever it says is the final. The recent time there have been attacks on the Supreme Court, specifically on the Chief Justice and even the mother of the Chief Justice. The Supreme Court felt that it is important to cite Prophet Key to appear to show call opinion why he cannot be held in contempt, but the meaning was and outright abusing the mother of the sitting Chief Justice. Prophet Key will be given due process in court. He will appear with a lawyer tomorrow If we tell the court, we give the court sufficient reason why he should not be here in contempt. Our law requires that he appear to answer. If he gives sufficient reason, he will walk away and do nothing has happened. So we are not hard from the king contempt. It is not true that he has been. But the court to be able to have you contempt, you must be giving your day in court. You must be called, you must be cited, and given an opportunity to answer. That's the process we are going through. Other people say why the past they are not happy. In the past, maybe he has insulted other people, but he has not insulted the Supreme Court. And the Supreme Court will not go look for case. Nobody has brought it to the attention of the court. But now that the court is under attack, the coconut law has the right to defend itself. So we ourselves are asking for lawyers to defend us. But what the law says, that when the court is under attack, we ask for lawyers to come and defend you. So our lawyer and his lawyer to be able to interpret the law. That's all we're trying to do. So please correct it that the Supreme Court of Nigeria has not anybody or property in contempt. All the radio, social.
Okay, we have seen this issue of clarification by the Chief Justice that Prophet Key has not been held in contempt, but the Chief Justice narrated otherwise that the court was under attack, and that if Prophet Kid has been doing this, insulting people, he has never come under the attention of the court, and the court is now under attack. The court has to defend itself, and therefore the court is going to look for its lawyer, and then Prophet Key look for his lawyer, and the Prophet Key is going to be given due process. So this is the case that is at hand, and the Supreme Court is deeply involved with this case. I take it that the Supreme Court intend to actually show some sort of discipline with respect to the behavior of Prophet Key. I don't know what exactly prompted the I don't know what exactly prompted Prophet Key to do what he did, and I don't know why the Supreme Court responded in the way that they responded. But here is the situation. This has become a legal issue, and so we have to weigh in on this. But I particularly am concerned because of my background as a human rights activist, and because also we were very instrumental in influencing the Kamara Abdullah Kamara act. So we own the Kamara Abdullah Kamara. We're very instrumental in influencing the Kamara Abdullah Kamara act while serving as executive director of the Independent National Commission on Human Rights. We've worked on the human rights We work we work with the Supreme, not the Supreme Court, but the executive in making sure that there was a passage of the Kamara Abdullah Kamara Act. Uh, we relied on what referred to as special rapporteurs that come from the Human Rights Council and that visit countries to ascertain the particular conditions within those countries with respect to the subject matters that they are dealing with. And so freedom of expression was the subject matter of the special rapporteur. And then we raised those issues with the president. And of course, President George Weah gave the assurance that the Kamara Abdullah Kamara Act decriminalizing free speech was going to be responded to. Now, the issue before us that we all should ponder with respect to what is obtaining between Prophet Key and the court is one, whether public allegations of corruption and abusive language directed at the Chief Justice of Liberia made outside of the court and unconnected to a pending proceeding constitute indirect contempt of court under Liberian constitutional law, or whether invoking contempt power in such a circumstances, meaning in the circumstances where the allegation is made outside of court and the allegation is unconnected with any pending proceedings. Under these circumstances, whether contempt power is consistent with Article 15 of the 1986 Constitution of Liberia, Article 19 of the International Covenant on Civil and Political Rights, and is persuasive and persuasive United States, like because we have a common law tradition. So we look at what a persuasive United States First Amendment jurisprudence is consistent as well. The next thing we want to be able to look at is what constitutional limits govern the exercise of contempt power when the judiciary itself is the alleged object of criticism. So usually the judiciary will stay outside of these kinds of things, and they are the final arbiter of justice, and they entertain cases and adjudicate those cases and dispose of them in the proper way. But this one is a direct attack on the Chief Justice, and the interpretation is that it is on the Supreme Court as well. So we've been able to state what the facts are as we know it, because it was Hoping we saw that on Facebook. I do not know whether Prophet Key attack was anything outside of the Facebook comment that he made. But so far, with this analysis, that is what we have as the fact. Prophet Key uses Facebook platform to attack the Chief Justice, accusing him of corruption, extortion, accusing him of involving himself in business. He built a hotel in Nima County. The hotel is as a result of stolen funds. So if you look at Article 15 of the Liberian Constitution, it provides for freedom of expression and of the press, but it also recognizes the responsibility for abuse thereof. So the Constitution recognizes that there will be abuse of the freedom, and anybody who abuses the freedom of expression will take responsibility for that. So, in other words, if you use your freedom of expression to defame other people's character, you must know that there is a limit. Other people get injured and you will be charged for defamation. Liberian courts possess inherent contempt power to protect the administration of justice, but those powers are constitutionally constrained and must be exercised consistent with due process and proportionality. If you look at the international human rights law, which Liberia is a state party to, you look at International Covenant on Civil and Political Rights, we look at there in Article 19, which permits the restriction on expression only if they are provided by law, they are necessary, and then they are proportional. So if you want to restrict free speech and you are developing your laws, international law is saying that that law must, first of all, you must state clearly that you are limiting free speech. And that limitation must be necessary. Necessary will means that it is trying to protect a particular thing, maybe public safety, for example. Public safety, for example, is trying to protect that and is trying to protect or hit. So it must be necessary, and then that protection that you're trying to provide, it must be proportional. The law must be proportional to the the protection must be proportional. The law to protect must be proportional to the harm that may be derived that it tries to protect against. A litigation aim including protection of the administration of justice, freedom of expression, and every possible litigation around that must be for a legitimate aim, including the protection of the administration of justice. So when we also look at the UN Human Rights Committee General Comment number 34, usually from the human rights perspective, we try to look at those general comments because they almost function as an interpretative instrument of the Human Rights Council with respect to the applicability and the functionality or the effect of a particular human rights law. So, regarding Article 19 on freedom of expression, General Comment of 2011 tries to clarify certain issues. Firstly, it clarifies that criticism of public officials and institutions is strongly protected. In the human rights context, if you criticize public officials, you they do not want a restriction of freedom of expression to limit people or restrain people from criticizing public officials or institutions. It also mentioned that contempt laws must not be used to suppress legitimate criticism of court. It also mentioned that mere insults, ridicule, or reputational harm does not justify sanction absent a concrete threat to judicial proceedings. So if there is an insult on the Chief Justice or any of the justices that does not interfere with ongoing judicial proceedings, the Human Rights Council or human rights law is not in favor of the limitation on the rights to freedom of expression. There are comparative United States law, particularly Bridges versus California. First, the U.S. First Amendment jurisprudence sharply limits contempt based on speech. Contempt sanctions for publication criticizing court are constitutional only where the speech poses a clear and present danger to the administration of justice. So in Bridges versus California, the US Supreme Court held that yes, there can be contempt sanctions for publication criticism, but only if the speech containing this criticism present a clear and present danger to the administration of justice. The alleged conduct constitute indirect constructive contempt. The conduct of Prophet K constitute indirect constructive contempt. It is indirect because it was made outside of court. Under constitutional norms, Indirect contempt based on expression demands a heightened showing of necessity, including intent to obstruct justice. So Prophet Key's statement must clearly be interpreted in terms of showing the intent to obstruct justice. So when the case goes before the court, the Supreme Court or the Chief Justice, to hold Prophet Key, will have to show his intent to obstruct justice, because mere statement alone is not sufficient. The court will also be required to show a real eminent and identifiable threat to judicial proceedings. Then there must be shown also a proportionality of the sanction. We got to be able to establish there are facts which indicate interference with a pending case, intimidation of witnesses, or disruption of judicial proceedings. We are still awaiting the contempt charge, the basis of the contempt charge, to know exactly whether the contempt is going to require or is going to show on the face that Prophet Key his comment on Facebook interfere with a pending case, or amounted to intimidation of witnesses, or disrupted in any way a judicial proceeding. Speech alleging corruption by a public official, including a judicial officer, lies at the core of political expression, and that is protected by Article 15 of our Constitution. A lot of the time, people will accuse President Boakai, or before President Boakai, President George Weah, or before President George Weah, Madam Ellen Johnson Sirleaf, President Johnson Sirleaf. A lot of time they will be accused of corruption and other things. They could have taken action on criminal defamation because the law existed at the time, but they didn't. Apparently, understanding these human rights safeguards, so while the Constitution recognizes responsibility for abuse, it does not constitutionalize contempt as the default remedy for offensive or defamatory speech. If a judicial official character is under attack, he's accused of corruption, or so to speak, Contempt are not default charges. There are other charges that could remedy this situation, because where reputational harm is alleged, for example, defamation law and ordinary civil process are the constitutionally appropriate avenue. So using contempt to vindicate personal reputation risks converting judicial power into a tool for self-protection rather than justice administration. Under the ICCPR, that is the International Covenant on Civil and Political Rights, Article 19 specifically, and General Comment number 34, judges as public officials are subject to public scrutiny and criticism. Restriction on speech must be must be demonstrably necessary to protect the administration, and it must focus on protecting the delivery of justice. It cannot simply focus on merely the dignity of reputation of the court. So there is protecting the reputation of the court on one side, and there is the administration of justice on the other side. The international human rights law will favor contempt where it interferes with the administration of justice rather than merely trying to protect the dignity and reputation of the court. So contempt must be issued where there is interference of justice. The international human rights law also cautions state against employing contempt powers to insulate the judiciary from accountability. So if every citizen knows that if they speak out against the judiciary, for example, the judiciary is going to bring up contempt charges against them, obviously nobody will want to say anything about the judiciary, even if they are corrupt. So absent threat to concrete threat, absent concrete threat to judicial proceedings, contempt sanctions will likely fail the necessity and proportionality test required under international law. When we look at the US Supreme Court precedent from the Bridges versus California case, that precedent strongly disfavor contempt sanction for speech criticizing court unless the speech create a clear and present danger to the administration of justice. Harsh, false, offensive criticism of judges is generally protected. Remedies lie in defamation law rather than contempt. There is a strong case against Prophet Key in defamation, because he definitely injured the reputation of the Chief Justice by saying that the Chief Justice extorted money from people in the US and the Chief Justice is corrupt. Those are statements that you don't make against people in such high offices. It is very clear that the statement was intended to injure the reputation of the Chief Justice, and it was made out of malice. And so Prophet Key can be sued civilly by the Chief Justice, except there is a law that prevents the Chief Justice from suing Prophet Key. But he can be sued civilly by the Chief Justice for defamation. This comparative authority is persuasive for Liberia, looking at the US case. Liberia can lean on it because there is no specific case where the Supreme Court uh, was directly attacked and tried to exercise. The court was directly attacked and tried to exercise a contempt power, and this issue came to question except this case. So we can borrow from the Bridges versus California case because of the shared constitutional tradition of Liberia and the US and the universal democratic concern over judicial overreach. When a court acts as both the allegedly offended institution and then acts as the adjudicators of contempt, heightened constitutional caution is required. The appearance of impartiality is a core element of due process under both Liberian and international law. So we will close by saying that contempt of court is constitutionally justified only to protect the administration of justice and not to shield the justices or the judges from criticism or reputational harm. So you can harm the reputation of a judge. Contempt is not the remedy. Contempt is not the remedy. On the fact presented, invoking contempt power based on solely offensive and accusatory speech made outside the courtroom without demonstrable interference with judicial proceeding raises serious constitutional concern under Article 15 of the Constitution of Liberia, Article 19 of the International Covenant on Civil and Political Rights, and even looking at persuasive US First Amendment and jurisprudence. The constitutionally safer and more appropriate or proportionate response lies in ordinary civil remedies, not contempt. When we always allow this celebrity of insult, Prophet Key, to escape responsibility for his action by the misstep that we take. First was Julie Andy, who proceeded to prosecute Prophet Key using outdated criminal law. And next is the court, trying to impose contempt charges on Prophet Key when it knows clearly that that would be almost impossible. Prophet Key will then develop the spine, the backbone to continue to do what he does, because a lot of people always missing Prophet Key. And what it signals to the rest of the Liberian society is that what Prophet Key does is a very good thing to do. First of all, it makes you very popular. Second, you become untouchable. Third, you are feared even by the judges. Because if the Supreme Court fail to bring Prophet Key under contempt, knowing fully well that it is impossible in the first place, then it shows that even the Supreme Court is incapable of handling Prophet Key. So we might, first of all, regard the attempt by the Supreme Court to issue contempt as a misstep. But this is where I want to leave you, and I will appreciate if you can leave your comment, especially for those who are lawyers and even the layman listening. You can leave your comment and let dialogue together. It has been a wonderful time. This is Vote 24 TV, and this is the Khakis Dialogue, where we try to make sense out of the debates in the public square. This has been your presenter, Heron Weedy. Thank you for listening. God bless you.